if somebody tries to grab the barrel of your gun, you know what Rittenhouse did? The guy threatened to kill him, so he pulled the trigger. And the rifle, you can hold on to it better than a handgun because of the.
Hey, so our next guest, somebody I really like. He wrote a book that's one of my favorites. I don't read a lot of books that aren't pop up or color. And he wrote one that is
so true.
He wrote one that is neither of those. And I got to tell you, it's one of the books I highly recommend to every Second Amendment advocate. And his name's Stephen Halbrook. We've had him on before, and I wanted to have him come on. In fact, the commercial and what John Dillon put on X is very relevant to what we're going to be talking about. The John Dillon, the attorney, Second Amendment attorney. Just remember, when the Founding Fathers drafted the Second Amendment, they were confirming the right for the public to own, carry, and defend themselves. With the most advanced weapons currently in existence, they would have loved the AR. We wanted to talk a little bit more to Stephen about this. Stephen, how you doing, man?
I'm wonderful. How are good you guys? Good to be on your program again.
Excellent. Well, thank you for being on. Give a little talk about the book. Talk about some of the book you wrote. I think you just wrote another one too, but specifically the Founders' Second Amendment was my favorite. I thought you did it is the definitive history of the Second Amendment, in my opinion. I think you did such a wonderful job. But could you just talk about give us your bio a little bit? Give us your background.
Well, first, the latest book is America's Rifle: The Case for the AR-15. So I've written a number of Second Amendment books, and look at StephenHalbrook.com on my website. You can find more information on the books. But most relevant now, I think, is America's Rifle, that book, because we got a cert petition pending in the Supreme Court on so-called assault weapon bans. But I've been doing Second Amendment litigation since actually started practice in 1978. I've argued some Supreme Court cases on gun issues, managed to win them. Filed briefs in the Heller and Bruin cases, and so I've been around a while, and I just can't believe how good I think we've had it compared to when I started this enterprise back in the 70s. You know, you had the collective rights view. Nobody has a Second Amendment right to do anything. It's not individual. It's some kind of collective mishmash that nobody knows what. And so we've got solid Supreme Court cases now, and the problem is getting these lower courts to adhere to those cases, because you've got so much resistance from the lower courts and the usual suspect states, you know, your state, New York, the other states where the judges who seem to get appointed on these federal courts by and large reflect the political values in those states. So you won't see the Fifth Circuit resolving an assault weapon ban because that's Texas, Louisiana, and Mississippi, and they don't pass them down there.
And that one of the ways of the and I think, of course, the big one that kind of tipped when things started going our direction was definitely Heller. But the Bruin case, you know, there was Heller, there was McDonald 2 years later, but the Bruin case is such an enormously powerful tool, and that's the way I describe it to people. Bruin wasn't the end. It wasn't the solution. It was like this huge, powerful tool that they handed everybody and said, "Here, now you're able to do the things that you need to do to protect and restore the Second Amendment." So there's a lot of cleanup that needs to be done in the courts, and like you're saying, some of the lower courts are simply ignoring it and are going to have to be pulled across the finish line, kicking and screaming, which is fine by me. But I don't know. Am I accurate there? Wouldn't you say that the Bruin case was like, here's your tool, go fight the fight. You now have a very, very powerful tool it's gonna help you win, almost every time.
Yeah. So we start with Heller, and Heller says the kinds of arms that the Second Amendment protects are those that are in common use by law-abiding people for lawful purposes. That's why they did away with the D.C. handgun ban, and the court could not have been more clear. I mean, first of all, arms means all bearable arms, because Second Amendment refers to that you keep and bear arms. Mm-hmm. And so all bearable arms, that's rifles, pistols, and shotguns. Hello. And so then we get all this resistance from lower courts saying that, well, we don't know what common use means. And just because there's, I don't know how many, 20 or 30 million people with AR-15s, that they're not in common use because they have to be in common use for self-defense, and we proclaim that they're not good for self-defense. So then we get to, Bruin, whether bear means to carry, which obviously it does. And there, Justice Thomas wrote for the court, if something's within the text of the Second Amendment, are you keeping and bearing arms, then it's protected, whatever the activity is. And it's up to the government to show that its restriction is the kind of restriction that would have been allowed at the founding or shortly thereafter, because that's what the words mean. The people who adopted the amendment, what was their intent? And if you don't like it, you can try to amend the Constitution. So we end up with Bruin, this, getting ahead of myself, the way they resisted Heller was to say that these guns are not protected. They're like military weapons. They're only useful for killing as many people as quickly as possible. They're not in common use by law-abiding people for lawful purposes. So then we have Bruin repeating the same dictum from Heller, saying that if they're bearable arms, then they're protected. And now we have so then the court overturns a Maryland decision, the Maryland so-called assault weapon ban being upheld by the Fourth Circuit Court of Appeals.
Yeah, the Bianchi case, right?
It was called Bianchi, but Mr. Bianchi hightailed it out of Maryland, so that we have another name that goes. His last name is Snope, Snope, versus Brown, and that petition was filed last month, and there's been no response yet. But the Maryland, the Fourth Circuit decision that was en banc, the full court, you had about 10 judges voting with the majority, which was written by Judge Harvey Wilkinson, saying ridiculous things like if you shoot somebody with an AR-15, it obliterates the person.
Right.
That there's nothing left. That bones and organs just shatter into nothingness.
Hey, Stephen, we're going to take a quick break, and we're going to come back and keep talking about this. Okay, we're talking to attorney and Second Amendment author Stephen Halbrook, and specifically we're talking about the Bianchi case, or Snoop case, as it's got changed to, which has to do with assault weapons in Maryland, which of course is the Fourth Circuit. And we were just talking about. So one of the things that we were talking about, some of the ridiculous claims they made, and my reading of, they just got, the ban was upheld, and my reading of their decision was they said, hey, look, the types of guns, AR pattern, et cetera, that you're talking about were intended for military use. Therefore, they're not protected by the Second Amendment, which is a completely ludicrous claim. I mean, the entire point of what they were trying to do was to make sure that people had the types of arms that they needed in order to serve in a militia in war. What are your thoughts on that? Am I wrong? What are your thoughts on her decision?
Well, the Second Amendment begins the well-regulated militia being necessary to the security of a free state. And they used to obliterate that and say, well, that really means the National Guard and it means government control. But militia arms were always held to be the most protected. And if you go to the founding and all the militia acts in those days, you had to have, every man had to have a gun and be able to be enrolled in the militia. And that system went by the wayside, and we have a volunteer army. We have pretty much volunteer National Guard also, but we have the reserve militia, of which all able-bodied people are members of. And but what do we have? These judges say things like, and this was in the oral argument in the Bianchi case, the AR-15 is the M16. And how ridiculous can you get? It used to be, ever since the 1934 National Firearms Act, the basic distinction was between full auto and semi-auto. And nobody ever questioned the idea that regular members of the public, without restriction, could possess semi-auto rifles. And we also had,
and we all agreed on that, by the way. But when the other side says that we refuse to compromise, that was a compromise. The gun community said, okay, we'll compromise there. You guys want to, in effect, pretty much ban full auto. In general, the gun owning public kind of said, okay, great. That's our compromise. That's one of the many compromises that the gun owner side has said. And there hasn't been an argument. Now they're trying to take that away.
Well, if you read this opinion by the Fourth Circuit, they're insinuating that maybe rifles of all kinds should be banned because they talk about rifle cartridges.
Right.
And they act like the 5.56, which was nothing but a varmint round in its beginnings. The way it obliterates everything it hits. It's not even legal for deer hunting in a lot of states. And what about the 308 and the 30-06 and all the classic calibers? They do a lot more damage, but the court acts like, based on this horrible woundings that are created by the .223 round, that you can ban them for that reason. And then they go to this distinction. Well, you should be using a handgun, a 9mm handgun for self-defense. There's no point in using a rifle. They're not suitable. And of course, the court says what's suitable. If you look at Heller said what the American people choose is what counts for what arms are protected, and they do choose handguns in part.
We get to decide what's suitable, not some bureaucrat who clearly doesn't know anything about firearms anyway.
Exactly, and these judges, you wonder, I mean, where do they get these ideas that there's no distinction between semi and full auto, and that these wounding capabilities of the puny .223 round, and there's several judges also dissented in the Bianchi case. Judge Richardson wrote the main dissent, and it's basic common sense. The arms that are protected are those that are in common use. And if you go back before 1989, handguns were bad, rifles were good. And California started it all with the Roberti Ruse Act. Mm-hmm. Here's all these rifles that are evil, wicked, mean, and nasty. We're going to make a list of them, and then we're going to define them generically. And if they've got that horrible protruding pistol grip, whoa, look out. And so, you have to have that, I call it the hitchhiker design. You have to have your thumb sticking up. You can't grip the gun. And then you have the most arbitrary distinctions. What's an assault weapon? So you've got conspicuously protruding pistol grip. You go to Cook County, they say, only if it doesn't have the shoulder stock, then it's banned.
Yeah.
But if it has a shoulder stock, it's not. And if you go to Maryland, they don't even have that characteristic at all. They mostly have the list of evil guns, and then they have a very brief generic ban, which is things like a grenade launcher and retractable stock, things like that. And They don't even have the protruding pistol grip. So these people are all over the place. Anti-gun groups write these laws. The people who pass them know exactly nothing about what they're banning. It's funny, it came up in the oral argument. Judge Wilkinson, who led the anti-gun judges, said, the legislature of Maryland must have had a reason why they put each and every one of these guns down on their list of which guns are banned.
They must be. Why would they put it there if they weren't reasonable?
Right, and the funny thing was, all they did was to copy lists that previous lobbyists gave them, and some of those guns were obsolete by then.
Which is such it's such a circular argument, Well, it's reasonable because we put it there. Well, why'd you put it there? Well, we put it there because it's reasonable. Well, why is it reasonable? Well, because we put it there. Hey, I want to ask you a question. Going back to what you were talking about with ammo. Where they talk about 5.56 is, horribly, lethal, and this isn't as lethal or whatever. And they talk about these degrees of lethality. That's kind of talking, is someone kind of pregnant? I mean, it's either lethal or it isn't lethal. And what I'm curious to hear is your opinion. I think that whole subject of how much damage a 5.56 does, or how much damage your grandfather's 30-06 did, or it blows the lungs out, or whatever. It's a total red herring. Lethal is lethal. The entire point of lethal force, is lethal lethality. And by the way, I've never heard an argument by the founding fathers where they were saying, hey, our muskets, they're not that lethal, so that's okay. I mean, everything they used, the intention was, lethality. So I guess my question is, first off, am I off base on this? And second, do you think that whole discussion is just kind of a red herring, and that maybe our side's getting kind of sucked into this weird, senseless argument that we should squash and never revisit?
Well, of course, our side exposes those fallacies. The founders liked lethal. I mean, they liked distance. They liked to be able to pick off those British officers and shoot them in the head with their rifles instead of just the common muskets with smooth bore. But that aside, you go down the list and they make these claims. If you want to read real literature, Dr. Martin Fackler was the expert. He's deceased now, but he was a wound ballistics expert in the U.S. Armed Forces, and he goes into all of these comparisons, comparing the 223 and then the 7.62 by 39, all of those cartridges, and they're all less lethal than alternative cartridges. And in fact, the Armed Forces has gone from the 5.56 NATO to the X-Ilm-7, which has a lot more muzzle energy. Mm-hmm. The 5.56 is a puny cartridge, and the whole idea of lethality and the idea of what are these rifles designed for? A firearm is designed to expel a projectile by action of an explosive. And what a person wants to use it for is different. And we're well aware that almost all Americans who own guns use them for self-defense, for sporting purposes, for hunting and things like that. And to say that these are weapons of war and they have only one purpose, to kill all these people in combat, it's just such a fantasy that they're living in. It's just such rhetoric that seeks to obliterate what the plain text of the Second Amendment says. Why would we want to keep and bear arms? It's to protect a free society. Those words are in the Second Amendment. And the fact that these are militia arms, or can be, they are the kind that ordinary people would bring for militia duty at the founding, and they were also used for civilian purposes. I mean, you couldn't ask for anything better than an AR-15, because at least it teaches you how the gun operates. The charging handle is different than the classic way that you would insert a cartridge into more of a traditional rifle. But it doesn't have the selective fire or the full auto feature. And so what we end up with is the kinds of guns that would be useful for militia purposes or would be useful for self-defense. These rifles were used for self-defense. If you look at public disturbances, or like the 2020 George Floyd riots, and you look what happened with some of the uses of the AR-15 at that time.
Yeah, enormously effective. Enormously effective at self-defense.
If somebody tries to grab the barrel of your gun, you know what Rittenhouse did? The guy threatened to kill him, so he pulled the trigger. And a rifle, you can hold on to it better than a handgun because of the pistol grip, and you're holding it with two hands. So they're well suitable for self-defense in civil disturbances, or in rural areas where you have a lot of distance that might be needed to be covered for defending yourself or defending other people.
Right. Hey, Stephen, real quick. So we have like 2 minutes. So I want to switch over to the actual legality. People who are wondering, all right, well, where are we? Is this going to the Supreme Court? We have the Miller case out here in California that's kind of on hold. We have the Bianchi Snoops case out in Maryland, where they're asking the Supreme Court to take a look at it. Can you just kind of spend about 48 seconds here and just tell us, like, well, where are we at as far as these lawsuits, and what do you think the next step is?
Well, the case that's most groomed for Supreme Court review is Bianchi, because there we have a final judgment. All of the evidence is in. There's no more rulings to be made. There's no point in remanding the case for any purpose. And so the time will tell whether the Supreme Court wants to go there. They've been doing a lot of gun cases, and we don't know how many they're willing to do at one time. There's cases percolating elsewhere, and in the Seventh Circuit in Illinois.
Awesome. Stephen, thank you so much. Everybody, check out his book, America's Rifle, and check out everything he's written, because I'm a big fan. You do such a great job. It's an honor that you give us the time and come on our show and talk about this stuff. So thank you very much, Stephen. I appreciate you very much.
Appreciate it, man.
Great to be on the show.
Thanks for watching this clip from Gun Owners Radio. If you're watching mainstream media, you're not getting the truth about guns. Gun Owners Radio is the easiest way to stay on top of the Second Amendment fight, the fight for your self-defense rights. You can watch our live stream on YouTube every Sunday from 4 to 6 p.m. California time, or if you're in San Diego, AM 1170, FM 96.1, The Answer. We're also available on your favorite podcast platform. Just search Gun Owners Radio and you'll find our show. Like and subscribe to help defend and restore the Second Amendment, not just in California, but across the country.